The Home Mortgage Law Show is a paid program and is intended as a resource guide for education, information, and entertainment purposes and is not intended to provide specific legal advice. The information that you hear should not be used as a substitute for competent legal advice from a professional attorney. Hiring of an attorney is an important decision which should not be based on advertising or the information that you hear today.
Good afternoon and welcome to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Shay DuPont and Will Morris, joined by George Fajardo, Director of Loss Mitigation. Our phone lines are open. It's toll-free, 866-610-6397, 866-610-6397. AT&T Wireless customer star 610. If you're on social media, log on and keep up. It's the Home Mortgage Law Show on Facebook, sponsored by Morris DuPont, PA.
Well, it's a sad day here in Florida,
Wow.
as far as I'm concerned.
Yes, yeah.
It's the passing.
Is that why you're wearing black, Shay?
Yes, I'm in mourning. I'm in mourning, Will, over the passage of House Bill 87, called the Mortgage Foreclosure Bill, which was sponsored by Representative Kathleen Passidomo of Naples in the House and Senator Jack Latvala in the Senate. It has now passed. It's now in the hands of Governor Rick Scott. Will, we've talked a lot about this foreclosure bill in the past.
Well, we've talked about it for the last, 3 years. Every year it seems to be another incarnation of it, and finally they've gotten it through.
Well, interesting that Representative Kathleen Passidomo of Naples, since she was elected to the to the House of Representatives, she has been absolutely the biggest sponsor of this bill, trying to get it passed every single year.
Right.
And of course, she's ecstatic that it's now passed the House and the Senate in the state of Florida and is in the hands of Governor Scott. We'll see what happens. Some of the things are positive about the bill, I will say.
Sure.
There's a couple of things.
Yeah, like lessening the amount of time that banks can go after homeowners for the deficiency judgment from 5 years to 1 year. That's not bad.
Absolutely.
People don't have to sit around for 5 years wondering whether or not they're going to have an independent lawsuit filed against them for the difference between what the property sold for and what they owe. That's by definition the deficiency. So that's good. I like that. I can support that.
I really like that part of it because in the first year or so,
Right.
they're absolutely going to miss the mark.
Absolutely.
They're not going to be able to get their act together that fast.
Right. And then they that right to be able to go after the homeowner for the deficiency would have been waived or not subject to a good defense called statute of limitations.
Absolutely. So that's very good news because people who have done a foreclosure, who have gone through the foreclosure process, their home has gone through a foreclosure sale and they had negative equity on that property, knew that they were vulnerable to be sued for that deficiency amount for 5 years by the original lender. And if the original lender sold that note, that debt to a debt collector, that debt collector had 5 years and 5 years up to a maximum of 20 years.
Right.
So it really is great news for Florida homeowners that has been pushed down to 1 year. And really, unless these banks go and hire
really
every
on top
single
of it.
law firm,
Right.
if they hire every single law firm in the state of Florida, maybe they could actually comply with that timeline. But I think it'll be difficult.
Sure. Well, the problem really is going to be if they sell that right to a third party, a debt collector, like you were saying. Then the debt collector is probably going to start sending out letters. And what homeowners would have to be very careful of is not reaffirming that debt. Let's say, for example, they come after you after the statute of limitations expired, that 1 year, and you say to them on the phone, well, gee, I can make payment arrangements to pay off that deficiency balance. Then essentially you would have reaffirmed that debt and possibly caused that statute of limitations to start running all over again.
Oh, that's very serious, Will.
Yeah.
Very serious.
Yeah.
So more we're going to be talking about as it goes through. If the governor goes ahead and signs the bill, we'll go into the details. I like the other part that they were touting as really a great success about this foreclosure reform bill, and that was that the lenders are going to have to produce the note at the time of the foreclosure.
What's new about that?
Isn't that already the case?
Yes, George. I mean, previously, did they not have to produce it?
Apparently not.
Could you just go into a court of law, file a complaint against a homeowner, and say they owe me $200,000?
And don't produce the original document. But listen, for non-lawyers, maybe that might sound impressive, but for us lawyers, we know that it's been true all these years throughout history that when the bank is trying to foreclose, they have to at some point before they can get that final judgment produce the original note. So no big win there.
Right. But let's talk about the part that's making me so
Ah,
sad.
yes, please,
The
let's do it.
mourning, which
Ah.
is the time frames and really, to me, lack of due process. Will.
Absolutely. Listen, there has been a statute in place, a little known secret that, particularly in commercial properties, that the banks that are seeking to foreclose, they can walk into the judge and say, listen, judge, rather than go through this whole rigmarole of a trial and a protracted litigation, let's have the borrower show cause why we shouldn't get judgment right now. And if that borrower doesn't hire an attorney and come up with the right defenses and file, a responsive pleading under oath, then the bank automatically gets a final judgment, and you don't have to go through the whole rigmarole. Well, lo and behold, this new bill applies that to mortgages as well, where homeowners association mortgage holders can actually come in and ask the judge to enter judgment now by requiring the borrower to show cause why the judgment shouldn't be entered. Now, if the borrower is not represented by counsel and sleeps on their rights and does nothing in response to this, guess what? A final judgment gets entered, and next thing you know, there's a sale schedule, and your property is gone.
So I have a question. How much time does a borrower have in which to retain counsel once they've been served?
Well, normally you have to respond in 20 days. If I remember correctly, it's a 30-day window within which the borrower has to respond and show cause by way of raising affirmative defenses why this final judgment of foreclosure shouldn't be entered. So it's a very short window, and even in the old days, prior to this bill being passed, even if you've missed that window and the bank maybe went ahead and got a default judgment, you could still probably hire an attorney. Not probably, you could still hire an attorney who can then go in and get the default set aside, and then let the litigation proceed under the normal course. Here, if you miss that window, it is gone. That window is closed. You got a final judgment and a sale date. Case over.
And once the home is sold, of course, you now have the right to actually go against the lender and possibly get the property back.
Right. Well, it used to be that, for example, in the old days, it used to be if you file a lawsuit, if it was improperly foreclosed on, you could probably get title back to the property, particularly if it's not sold to a third party, what's called a bona fide purchaser. Now with the new bill, all you can get back, you can't get back the property even if it's sold incorrectly. All you can get back is monetary compensation for it.
So you've lost your home.
Lost your home. And we all know what the monetary compensation is all about. If we look from the Independent Foreclosure Review, people are losing their houses and getting $3,000 for their troubles.
Yeah.
So the lesson here would be to go out and get an attorney even before you're served, when you
Yeah.
receive a notice of default or when you know you're about to go into
The moral of the
financial
story
trouble
is-
and stop making your payments.
The moral of the story is get yourself counsel from the very inception. Otherwise, within a very short period of time, there can be a sale on your property and you can be out.
Isn't this basically turning Florida from a judicial state to a non-judicial state, Will?
Essentially, look, the argument would be, look, we're still requiring the judges to enter a judgment in order for a bank to be able to foreclose on a property. But when you streamline it that much, you're essentially turning into a non-judicial state.
Very frustrating.
Yep.
Question. So now what happens to cases that are being actively defended?
Therein lies the other rub. That's the other rub. Normally they say you can't enact a law and then have it apply retroactively. Apparently, this new legislation is going to be allowed to apply retroactively. If you ask me, that is unconstitutional. There's something called ex post facto law. There's a constitutional provision that says you cannot enact any sort of ex post facto law, which means you can't apply a law to matters that have been pending before the law has actually been passed. And this new legislation seems to be doing that.
Very, very frustrating for homeowners in the state of Florida. I'm not sure why there's some people that are excited about this, because when you look at the pros versus the cons, I would say that the cons greatly outweigh.
I say so too.
You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Book your free consultation now. It's 1-800-974-2712. If you can hear the show, there's an office near you, the law offices of Morris DuPont. 1-800-974-2712. More of the Home Mortgage Law Show coming up after this. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Will Morris, Shay DuPont, and George Fajardo, Director of Loss Mitigation, on our flagship station, News Radio 610 WIOD and 970 WFLA. The number to call the show and talk to the experts for free right here, right now is 866-610-NEWS. That's 866 610-6397. AT&T Wireless customer star 610.
And I'm glad to see George Fajardo here today, our Director of Loss Mitigation.
Well, that can only mean one thing.
A Rocky segment.
Well, I was thinking something else. He's trying to get out of the house from his wife and kid. But listen to
Oh, well.
Just kidding, George.
At least he's
Touche.
consistent, George.
There you go. Yeah.
So
I've
sorry.
been getting very good advice from Will for the past 3 years.
So sorry.
George, you've got a Rocky segment for us today?
Yes, I do.
You know, I'm always looking forward to that. When might we be hearing that?
I would say just around the turn of the hour, 2:45, 3 o'clock.
Love it. Glad to hear it. Well, we made it through this week, George. You missed the Take Your Child to Work Day.
I did.
Well, I purposely took it off because,
Yes, I held down the fort, guys. Not to worry. It was me and 20 children running around the office. Yes, I held down the fort.
Oh, my
How
God.
convenient that you were both absent that day. Both with good excuses, I know. Will, you were off doing some work in Haiti.
Right.
George was home in mourning. I know. I'm sorry.
Yes, the loss of a family pet.
I'm very sorry to hear
unfortunately.
that. It's very sad when that happens. I know. I've been there. But the office was great. This past week, we had all the children in.
She's giving me a funny look because I just pointed to our Facebook picture from the corporate run.
Oh, yeah. The corporate run the week
week,
before.
right. We were busy.
Yeah, absolutely.
Yeah.
We were involved in the Mercedes-Benz corporate run in downtown Miami. We had the employees of the firm there, and we posted those pictures on our Facebook page. You're welcome to share the joy. The Home Mortgage Law Show, sponsored by Morris DuPont on Facebook. Like the page, check out the pics. Yeah, you can see what we all look like in our best racing gear.
Yeah.
I'm the skinniest and prettiest in the picture.
There you go.
Always,
go.
Natalie.
Always.
Always.
There you go.
That's always
Well,
true.
I have a stunt person in there.
Will's body double.
Nobody don't.
You know, there's been a lot of talk about principal reductions. We're getting lots of principal reductions, but they're
Yeah.
never on a Fannie or a Freddie loan because Fannie Mae and Freddie Mac do not allow for principal reductions. Why can't you get a principal reduction when you have a Fannie or a Freddie loan?
Just because they say.
It's funny. I always tell clients it would literally take an act of Congress for
Right.
that to change. And it's true.
Right. Or change in leadership.
And it looks like we might be having a change in leadership because the reason that you cannot get a principal reduction on a mortgage that is held by Fannie Mae or Freddie Mac is because the acting director of the Federal Housing Finance Authority, which oversees Fannie and Freddie, Edward DeMarco, does not believe in principal reductions for homeowners. So,
Well, he's got a more technical reason. He's thinking that because that agency is a creation by statute. He's saying to do that would exceed the authority given to him by the statute.
and yet Obama says it wouldn't.
There you
And
go.
yet
Imagine
Congress
that.
is saying it wouldn't.
Imagine that.
So we are hopefully on the break of a new head of the Federal Housing
Absolutely.
Finance Authority. And we've got a nomination. That nomination is President Obama nominating U.S. Representative Mel Watt. Mel Watt is a congressman from
North
Carolina,
Carolina.
a Democrat, obviously, and hopefully he will pass nomination. And he does believe in principal
Well, he said it
reductions.
in the past.
Absolutely.
He's been calling for it in the past. But, his nomination is not going to be a perfunctory matter. I think he's going to run into some problems.
Well, don't they all?
Yeah. Well, this guy's, Republicans are already lining up against him, so we'll see what happens.
Well, there's those who say he's not qualified for the job.
Well, there's that too.
Well, plus there's a problem that he signed actually a December 2012 letter to Obama and congressional leaders urging them to include principal reductions for borrowers with Fannie Mae and Freddie Mac loans. So we know right off the bat
Right.
that he would have a completely opposite philosophy from Edward DeMarco and that he would agree to principal reductions.
Yeah, but DeMarco's position was sort of like, it was sort of supported by the evidence. Everybody came out and said that, look, this will save taxpayers money. As a matter of fact, there's a recent article which came out and said it will save, principal reductions across the board will save taxpayers $2.8 billion. And so it contrary to the evidence, DeMarco took that staunch position.
Well, actually, it was the Congressional Budget Office that released the result of its own investigation into potential costs for a widespread. I don't know why I'm having trouble today. having a widespread mortgage principal
Maybe it's George. Don't
reduction
look at George.
program, and that was $2.8 billion in savings if we could have principal reductions on these Fannie and Freddie loans.
Yeah, and not just principal reduction, but a specific type of principal reduction plan known as the shared appreciation principal reduction program.
And that Preserving American Homeownership Act of 2013, which was introduced to lawmakers, that is a bill that would establish a pilot program to encourage the use of shared appreciation mortgage modifications. That's still sitting actually in subcommittee, so we don't know if that's going to happen. But let's talk about shared appreciation mortgage modifications, George, because we've been dealing with shared appreciation mortgage modifications for the last 3 years because there is one lender out there today that does them.
Yes, and that's Ocwen. Ocwen was the servicer that spearheaded that program, and we've been successful in negotiating a lot of loan modifications with that specific type of principal reduction plan, by where the lender stands to gain a portion of the equity that the property builds over time with this program. Essentially, the way it would work is, let's say you have a mortgage and your current balance is $300,000 today, but the property's worth $100,000. And through this program, if the lender forgives the negative equity of $200,000, bringing your principal balance down to the current market value, under the terms of the program, if the property sells, let's say 5 or 10 years from now, and it appreciates $50,000 during that time, they can stand to gain somewhere between 25% to 50% of that equity that the property gains. So they stand to recoup a portion of the negative equity that they forgave as a result of the modification.
One of the more common sense solutions to negative equity out there today, folks. If you understand what George just said, the shared appreciation program allows lenders to reduce principal on a mortgage to the current market value of the property. Then in the future, if the home sells, that lender gets a share of the profits of the sale of the home. It only makes sense.
And what happens? You have now a performing loan during that period of time before the property is sold, because now you have a borrower that is paying again.
Right.
Absolutely.
He's gotten his monthly payments reduced, and he's paying, and he's got building equity in the house. It just makes sense that he shouldn't walk away with the full benefit.
It creates a lot more incentive to
Absolutely.
continue paying on your mortgage and remain current.
I love the shared appreciation program. I can't understand why it hasn't gained more traction, because even if there was a bill, we don't need a bill. These lenders can go ahead and adopt a shared appreciation principal reduction program today. Ocwen did it, and there is a report this week that Ocwen's profit has more than doubled. Well, you've got to think
it's no coincidence
that some amount of that is because of these great loan modification programs they have, where they do agree to forgive principal, but they take a percentage of the value of appreciation if the home sells in the future. I love it.
Yeah, I love it.
And wouldn't that be great? We could see more principal reductions. We could see more people being able to stay in their property and to be able to make their mortgage payments going forward. That's one of the goals of our clients that come in to see us at Morris DuPont. Remember, you can schedule a free consultation with the lawyers at Morris DuPont. Any of our offices from St. Petersburg, Tampa, Doral, Dadeland, Aventura, Fort Lauderdale, Plantation, Boca Raton, and West Palm Beach. We offer a free consultation, whether it's a loan modification, a short sale, a deed in lieu, a short payoff. What about that second mortgage that's now completely unsecured because you're underwater on the first mortgage on your property? What are your options going forward? We'll sit down and discuss them with you in that free consultation. Call the law firm of Morris DuPont at 800-974-2712.
Again, that number 800-974-2712. I see Robert's waiting for us to answer his calls. Robert, we'll get to you right after the break here on the Home Mortgage Law Show. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. Attorneys Will Morris, Shay DuPont, and George Fajardo, Director of Loss Mitigation, here for you as we are every Saturday afternoon from 2 until 4 o'clock. Our phone lines are toll-free. Call the show, 866-610-6397, 866-610-NEWS, AT&T Wireless Customer star 610. Want to give you a heads up that coming up in our next break, we have our infamous Rocky segment, which is...
Infamous?
Infamous.
I beg your
No,
pardon,
it's
ma'am.
famous. Popular.
You think it's
World
very
renowned.
famous?
I think it's
George better keep going with this, because every time they get better and better and better.
famous.
Well, a Rocky segment, folks, is when we have an actual client who is a client of the law firm of Morris DuPont. We have them join us in the studio, either telephonically or in person, and they really give you an explanation of their hardship, what happened to them, what led them to seek out help with their mortgage, how they came to get together with Morris DuPont, and then what happened during the process that they were with Morris DuPont. And we helped them out maybe with a loan modification, with a short sale. Maybe we were able to have a second mortgage completely forgiven. Maybe we did a short payoff for them where they actually paid off their mortgage for the current market value, when what they owed the lender was actually maybe twice, maybe 3 times as much as the current market value of the property, but they actually had the funds available to make an offer to the bank where they would agree to pay off the mortgage at current market value, and they then own their home outright. And they could actually then go out and refinance that property because they have positive equity in the property. There's lots of different solutions when you find yourself either unable to make your mortgage payments, or that your property is so underwater, you're wondering, does it really make sense to stay in this property? Even though I'm making my mortgage payments on time, the fact of the matter is I could make those mortgage payments for the next 10, 15 years, and I still would not have any equity in my property because of how underwater that property is. Unfortunately, in Florida, 1 out of 79 persons find themselves unable to make their monthly mortgage payment. They're in default. They're looking for answers as to how they can solve this horrible dilemma. And here we are at the Home Mortgage Law Show, looking to provide you with answers, looking to offer you solutions so that you can either make your monthly mortgage payments on time by actually getting a loan modification to reduce those monthly mortgage payments, or finding the right exit strategy for you so that you can have the least damage to your credit score. You can walk away with no personal liability on a mortgage. That could be either through a short sale, a deed in lieu. I know, Will, you all are doing a lot of consent judgments over there in the foreclosure department.
We certainly are. And even though we may go ahead and have a consent judgment entered, assuming the bank has all its ducks in a row, a person can still proceed on and gets any sort of loss mitigation options explored, even after a final judgment is entered on the property.
Well, what I like about those cases where a consent judgment is negotiated is that Will's team is usually pretty good about attaching a waiver of deficiency to those.
Sometimes we do. You know, look, and if you wind up getting a waiver of deficiency, then what's the point of trying to do a short sale or anything else? Because that's the whole purpose of maybe trying to explore that loss mitigation option of a short sale, is to get that waiver of the deficiency. And if you can get that in a consent judgment, then everybody's happy.
And I understand in a consent judgment, you're actually able to keep the homeowner in the home for even maybe 4 months?
Yeah, up to 120. Sometimes we've gone as far as 160 days before the sale is actually scheduled. And even after the sale is scheduled, there's still maybe an additional month on top of that. So give the homeowner enough time to get their affairs in order to move on out.
So, folks, if you have missed a mortgage payment, if you are unable to make those monthly mortgage payments going forward, if you're making partial payments to your mortgage holder, you need to contact the law firm of Morris DuPont, schedule an appointment so that you can understand what your options are going forward before you get to the point where the lender is actually filing a foreclosure action against that
How do they
property.
do that, Shay? How do they get a hold of the law firm?
Well, they call the number 800-974 2712. If you're driving, you don't need to remember that. Just remember these keywords, homemortgagelaw.com. That's the website for the law firm of Morris DuPont. That's homemortgagelaw.com. You will find our contact information on the website so you too can schedule your consultation. Remember, offices available: St. Petersburg, Tampa, Dadeland, Doral, Aventura, Fort Lauderdale, Plantation, West Palm Beach, and Boca Raton. I know we have some calls on. Let's take some calls, Natalie.
Okay, Robert, welcome to the show.
Hi, Robert.
Hi, how are you?
Good. What can we do for you today?
Yes. I actually first I had a bankruptcy on 2011. Then I had a discharge on 2012.
So that was a Chapter 7 bankruptcy.
Yes.
Okay.
And I have a property. I would like to see if I can do a refinance and if I would qualify for that. I owe around 118. Market value is probably around 145 to 150. It was a conventional loan initially, and I would like to know if within do a refinance with the same bank that I had with. What procedure should I follow?
Okay. So refinancing a property that has positive equity on it, which yours certainly does, is just a matter of either contacting your lender that is currently holding the note or contacting a mortgage broker to see whether or not you can qualify. And it's simply a matter of your credit score. It's a matter of your income. I do believe, Robert, it's going to be difficult because of that bankruptcy, but difficult does not mean impossible. There may be lenders out there who are willing to work with you to help you to refinance that property that does have some amount of positive equity. The problem comes for most people when they have negative equity on the property and they're trying to refinance. And the only properties that qualify for a refinance that have negative equity are those that are held by Fannie Mae and Freddie Mac, and the program for those properties is called HARP, the Home Affordable Refinance Program, that is available to homeowners that have negative equity on their property. Again, they would have to qualify for a mortgage just like you would have to qualify, being able to show income and being able to show a positive credit score and credit report. George, how do you think that bankruptcy is going to affect Robert's ability to qualify for a refinance on a property with positive equity?
Well, the first thing I looked at was the loan to value. In other words, the current balance relative to the market value, which based on the figures he provided, you're at an 81% loan to value. So my concern there would be that the bankruptcy, depending on how it affected your credit scores, depending on how much of a hit your credit scores took, that might set a limit to how high the lender's willing to approve you for in terms of loan to value. And so anything above 80%, you really begin to get into that range where you really need to have higher credit scores, and all of your other qualifying factors have to be along the top echelon as far as approvals are concerned.
So if Robert was able to pay down some amount of principal and get the loan to value ratio lowered so that he was at maybe 70% LTV, do you think that that would give him a better chance of qualifying for the mortgage?
Either that or paying for the closing cost out of pocket, because in any refinance, you also have to factor in the closing costs, which get added to your principal balance and rolled into the new loan. So that's where that could take him from an 81% to anywhere between 85 or 90%, which may take him out of that qualifying criteria because of the bankruptcy.
So, Robert, you're going to want to contact your original lender or a mortgage broker. What area of town do you live in?
In Riverview.
In Riverview. So you might want to contact our mortgage broker extraordinaire over there in the Tampa Bay area, Pam Marin, Marron, and contact Pam and see if she can help try to qualify you for a refi on a property that has positive equity but with a bankruptcy on your credit score.
Okay. Well, I thank you very much.
All right. Well, thanks for listening to the show.
Bye-bye.
Okay, let's get to the next call. It's Jeremy.
Hi, Jeremy.
Hi, how you doing?
Hi.
Great. How can we help you today? We've got a minute to take the question. We might not be able to answer it in that minute, but let's hear the question.
Yep, had a foreclosure that turned into a short sale, and throughout that process, there was a sinkhole claim for an insurance claim. That money went to the bank in escrow. The short sale has since closed and is gone, and that money is still sitting in escrow from our account, and the bank doesn't want to seem to do anything about it.
Ooh, that's a
Ooh, that's
problem.
interesting.
How much money are we talking about?
About $40,000.
And did the lender agree to waive the deficiency amount in the short sale?
They did,
And
And how much?
even if they go back on that, or my fact is incorrect, the deficiency amount is only about half of that.
Ooh, you should hold on.
Right.
Hold on with us. We'll discuss it during the break, and we'll have an answer for you when we return.
You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. 800-974-2712. That is a free consultation, one phone call away. 800-974-2712. Much more of the Home Mortgage Law Show right after this. You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morris DuPont. 866-610-6397. That's our studio line. And you are featured today with our attorneys, Will Morris, Shay DuPont, and George Fajardo, Director of Loss Mitigation. We're on the phone with Jeremy. And right after Jeremy, we've got a Rocky segment.
Jeremy,
I'm here.
the issue that you brought up in that you have done a short sale, but there is also an outstanding insurance claim check for $40,000 that your lender is holding is actually a scenario that we see time and time again in the Tampa Bay area. So this issue is very timely. I know we've got a couple of clients who have that issue. In fact, we have one client that's actually holding a check for over $90,000 that has to be endorsed by, of course, his lender and him before it's cashable. So this issue is not unusual in the Tampa Bay area. So we have a couple of questions to more fine-tune the issue so we can give you a proper answer. Number one, did you have counsel representing you in the short sale?
We had a realtor in the short sale.
Okay. And was the issue of the $40,000 check dealt with on the closing statement, i.e. the HUD statement?
I do not believe so. The talks about any escrow came down to all escrow accounts will be closed after payment is received and the account is closed. Then any outstanding balances in escrow will be distributed.
Okay.
And that was as simple as it was talked about.
Okay.
Well, I'm not so sure the escrow and that check are one and the same thing.
Well, what I would first like to find out is exactly how much the deficiency that was waived, how much that exact amount was. What was your current principal balance at the time of closing?
The principal balance was $40,000. I'm sorry, $60,000, and the home sold for a little over $40,000.
Okay. So there's also included in a sale of a property, obviously, there's
The
closing
closing,
costs
right.
involved, and there's real estate commissions. So do you know exactly what the difference was between what the property sold for, including closing costs and real estate commissions, versus what was owed to the lender?
The difference was approximately $23,000, and we even roughed it out with them, including the extra insurance coverage for this year that they forced upon the property, and such taxes, including all that. It still came out to over $10,000 that should be net back to us if they include that. However, when we call and discuss it with them, they keep threatening to send a 1099 for the deficiency, and that we should leave them alone.
Oh, that's
my
horrible.
God.
They're going to do that anyway, aren't they, Shay?
This was your primary residence, correct?
It was, and then it became a rental residency, and upon it becoming a rental residency, it went under.
Okay. So primary residence, you resided in it for 2 of the last 5 years.
No, it was a rental residency when it went under.
Okay.
So it was an investment property.
Had you lived in it for 2 of the prior 5 years?
Yes.
Okay. So it can qualify as a primary residency. So, of course, you're going to get issued a 1099. There's
Always
no
happens.
way you can't
Right.
get issued a 1099, except for the fact that actually I would argue that there's no deficiency because if they apply the escrow
Absolutely.
funds to
Well,
the
he's got-
past due amount, there is no deficiency.
Well, he's got two ways to fight that. One, he's going to get the tax credit,
Yep.
right? And then two, there's no deficiency to waive. They got paid in full.
Yeah. And the problem is, as I hear it, is that you're simply calling Bank of America. You need probably to be writing and making demands to the correct department. And if that doesn't work, honestly, I think you're going to have to hire counsel. Sometimes it's as simple as a letter coming from your
letterhead.
legal counsel on legal letterhead.
That's right.
Yeah, well, the problem is you can never reach anyone that has any authority to make a decision on something like that when you call.
Or
You'll never be able to reach that person.
Or the correct department. Every time we
Right.
cut off one head of which department to talk to, 2 more grow back.
Well,
So,
yeah, that happens all the time. The other thing, that whole threat about the 1099, disregard that.
Yeah.
It's not really a threat.
yeah, and then that was somewhat expected anyhow, and which after going over with the our tax person, they said that the values versus what's owed personally and the 1099 that it will not affect our taxes anyhow.
Well,
So
there you go.
Yeah, I agree. I consider the
agree.
1099 threat to be an absolute non-issue, so let them threat away. It's not relevant to you. Secondly, I think everything has to be in writing, and the worst case scenario is that we have to file a claim against Bank of America.
It's probably, chances are it never gets to that.
Yeah.
is there a legal timeline that they are supposed to follow to disperse funds and to resolve such accounts?
It depends on how that money is categorized. And because it's these insurance claim funds and because you did a short sale, it's kind of cloudy as to what timelines we would have to be using. So once we did some research and looked at how are we going to categorize this claim that's most beneficial to you, because they would obviously have to allege differently if they were going to dispute it, then we would be making those claims in writing to Bank of America, to the correct department. So you're welcome to contact us. It would not be an expensive thing to do because you're just talking about, look, let's not try and escalate this into a huge lawsuit
Right.
and eat up all of those funds. How does that benefit you, right? That's not the kind of law firm we are. What we'd be looking at is how can we minimally spend the least amount of money to see if we can get the result that you want, which is to simply get you the money. So if it's just a matter of writing a letter, it's not going to cost a lot to do that.
A nice official inquiry with a nice official response. It sounds great.
That's
Right.
what we're looking
Absolutely.
for as a start. Let's see if we can get it there. So give us a call, 800-974-2712. And Will Morris, my litigator partner, would, I'm sure, be happy
I'd
to
be
take
more
that
than
on.
happy. Love those little issues like that. Love them.
Thanks for
All right,
calling.
I
Thanks for
appreciate it.
listening to the
Thank
show, and stay with us for the Rocky segment.
All right. Have a great weekend.
You too,
Thanks.
sir. All right, Georgie.
Oh,
Well,
I
it's
love
that
that
time
music.
again. And so today we have a client of the firm, BJ. He's been with us since March, and of 2012, and I know that he's got to be tying up his shoelaces right about now.
Putting on his sweatbands.
Hey,
and-
BJ.
Hey, good afternoon, guys.
How are you?
Well, very well, thank you. Thanks to you guys.
Well, I've got to tell you, folks, we have been in contact with BJ, obviously, as a client for quite a while, and he has been so excited about, come on, get me on that Rocky. Get me some good results. I want to be a Rocky on the show. And and BJ, the day is here.
I
There you
think that was
go.
the first question you ever asked the day you retained the firm, was it not?
It was, but Shay, I have to interrupt you and correct you. The results were never in doubt
Aw,
from day one. So I
Right.
appreciate everything you guys have done for me.
how kind of you to say that.
Excellent.
Well,
Excellent.
Let's talk a little bit about the day that you came into the firm. You
Yeah.
retained us back in March of 2012. What brought you to the firm?
Well, this show, I lost my job in late '08, and then I decided to scratch my entrepreneurial itch. Went out on my own, and knew it was going to be a tough road to sled, and it was a little bit tougher than what I imagined. But things were starting to improve, and then I got the the fateful knock on the door in early 2010, served papers by your friend down there, Mr. David Stern. And then I attempted on my own 2 different times for about, a year apiece to negotiate, deal with Bank of America on my own, to no avail. And then it appeared that I was, had reached my wit's end with them.
Then after, let's take a break there. We're going to go to our top of the hour break, and we're going to come back. But hold that thought, BJ. We want to hear more about it.
You're listening to the Home Mortgage Law Show, brought to you by the law offices of Morse DuPont. 800-974-2712. That's the number to the firm to book your free consultation. 1-800-974-2712. The Home Mortgage Law Show. More of our Rocky segment coming up after this.